Okay, welcome everybody to the Saturday night online law class for the Vocational Science of Freedom. Tonight we'll be going over information about the settlement of our states, how to claim your birthright, and VSOF status documents and what they do. So as always, if you want to join in on the Gilded server, you can always join in by clicking on the Vocational Science of Freedom YouTube page, and you can go and click on the About section, and then the link to the Gilded server will be in the lower part of the About section. And you can click on that and then join the Gilded server. And then we do so make sure that you click apply and not just follow. If you just click follow, you won't be able to interact with us and join in and interact and talk back and forth and join in the posts and whatnot. So make sure you click apply. It'll be up here in the upper section when you get onto the Gilded, right under Vocational Science of Freedom right here. So tonight we're going to open up the docs, and the mega link for the docs tonight is posted on this class 4 docs, and it's also posted in the chat server for tonight's class. So the first doc we'll be covering is Zen's email explanation of what happened to our estates. This started out as a document that was an email, and it kept growing. Luckily, the first time I did this for someone, they were not exactly sure about a lot of the things that I was explaining to them or that they'd heard here and there through some of the classes. And I just wanted to condense everything and give, as clear as possibly could be shown, the history of what's going on in the history of American jurisprudence and English jurisprudence as to how they've brought this Roman civil law system over the top of first England and then us, and the war between Roman civil law slash, if you will, the law merchant, and common law or natural law, the law of the people, as was laid down in the Magna Carta and in the foundational documents of this country and republics, which clearly showed that we are sovereign and we will always remain that way. And what they had to do was come over the top of us through force, fraud, lies, coercion, and contracts to alter what we had set down, because we had to basically enter into it willingly. So, as usual, the document's color-coded. Purple are my notes, red is what needs paying attention to, and then aqua blue is what needs paying even more attention to. So I'll skip this little part. This is just something that I put out to people. You, the living man or woman who has come of full age, must come forward and claim and settle your entire gross estate. You, as one of the people of your respective state, i.e. John, Henry, House of Doe, must come forward, have been found to be living, and claim your estate, the dead thing on the public record, in the form of a will and claim, to what I and others have come to affectionately call the straw man, what a lot of people call the straw man, which is the all capital letters name on the birth certificate. But here's the thing about the birth certificate. Not everybody's birth certificate has an all capital letters name. I've seen some fairly elderly gentlemen's birth certificates where only their last name was capitalized. I've seen some even older gentlemen's birth certificates that they were in upper and lower case. So the name of the estate is whatever is registered on that birth certificate. It doesn't necessarily have to be all caps, and just pay attention to that. So anyway, the IRS calls it a decedent, which means basically that you're pending death, that you're not living, not dead, but just pending, because they don't know what you are, because that's the whole thing, that you're supposedly lost. So now the name on it, again, like I said, is this. This is your estate. And an estate is everything that a man or woman owns in law. Okay, it's not a corporation. All these people out here consider themselves some sort of gurus in teaching people about laws in the system. It is not a corporation. A corporation has a charter. A corporation, usually, but not always, has stock. Now, a corporation is a trust, but not all trusts are corporations. So what they do with your estate is they administer your estate all the way through your life, and sometimes they put some of the res, R-E-S, meaning the property and stuff of the estate. Sometimes they put some of the res of your estate into a trust, which will have a different name. Okay, so usually the Social Security trust name will be different than the name on the birth certificate. So pay attention to that. So to continue, why else would we fill out Class 5 gift and estate tax forms with the IRS every year in the form of W-4, W-9, and 1040 forms? It is just an estate held in probate. Now, Class 5 is gift and estate tax. So you're paying, it's not income tax. W-9s are not income tax forms. Neither are 1040s. They're class 5. They're gift and estate. So why would you be paying in a tax to what? Use your own property? It's because you haven't claimed it. And because the IRS and everybody else and all the corporate state minions and idiots and judges and bar associates all think that you're a trustee. And that's how they treat you, as a trustee of the estate, not as the sole lawful heir and executor, or executrix as the case may be, of that estate. So the name's in all caps because after you're abandoned at the Foundling Hospital, and a foundling is a lost or abandoned child of unknown parentage, and that's what foundling hospitals are. They're there to find lost and abandoned children. So the estate's created and set as the name at the Foundling Hospital because you were abandoned there by document, by the birth certificate contract being signed, where your mother signs as an informant. And for 7 years, no one comes to claim you, right? So you, the living, are considered to be dead under the presumption of death that no one came forward to claim your estate. And we'll get into the presumptions and I'll show you out of the dictionaries where it clearly shows the 7-year presumption of death, and even sometimes 5 years. 5 is about the lowest they've gotten it. And that makes sense because when do you start kindergarten? Always after the age of 5 years, right? So after you're born and you're abandoned, an announcement was given to the father or anyone else in the local newspaper regarding the birth, right? And how are the announcements usually set up? They'll say, a baby boy or a baby girl, right, was born such and such and whatnot. Now, if you look up the definition of the letter A, literally the definition of the letter A, you will find out that the letter A stands for a stock announcement, okay, in Black's Law Dictionary. So they're telling you that, hey, we're announcing this new creation, this new thing. Anybody want to come claim it? And of course, nobody does. So when no one comes forward to claim it, the corporate state of thieves then basically picks it up. The child is foundling, deposits his or her estate into and with a trust company, which is the DTCC, located at 55 Water Street, New York. And the DTCC then appoints the entire bar association to administer the estate property of you, meaning being now a ward of the state, until someone comes forward as having been found to be living, as is stated in the Certificate Act of 1666 in England, to claim it, of all of which we will get into this document. This document is 23 pages long. So let's look at the presumption of death. From Bouvier's Law Dictionary, 1856, which is the only dictionary you should ever be using when you're dealing with American jurisprudence. By 3 separate acts of Congress, this is the dictionary that you want to use. And specifically when it comes to constitutional issues, because it's specifically written for American jurisprudence. Death, the cessation of life. 1, it is a general rule that persons who are proved to have been living, proved, right? How does one prove that they've been living? Well, in the Certificate Act, it says that you have to prove in an action that you've been living. Okay, what kind of action proves life? Proof of life and proof of age, inquest, right? An inquest, which is done by a judicial coroner. So that persons who are proved to have been living will be presumed to be alive till the contrary is proved, right? So once you do this, then they have to prove the contrary. And when the issue is upon the death of a person, the proof of the fact lies where the party who asserts the death. They've got to prove you're dead after you do your doc set and prove that you've been found to be living. But see, the presumption will stay there until you prove that you've been found to be living in an action, which is what the Certificate Act says. And none of this has changed ever since 1666 and prior, because we talk about time frames, which is something I dropped in the main chat today, that I'm not digressing, I'm just making a note here to people. If you want to look up something really interesting, I put in the main chat today, the proof of age inquisition. Now this is directly out of Wikipedia, right? So you guys can go click on that too and take a look at that. And these proof of age inquisitions, this particular one that I took this information out of from Wiki, goes all the way back to 1289. So this was English jurisprudence for a very long time. Anyone who was considered a ward or who had their estate being administered by someone had to, at some point, come and what was called sue out their livery. So they'd do a proof of age inquisition. And this is one little short snippet from it, of an aspect of what was in this particular one. And it's much longer. You can read the rest of it on Wiki if you want to. But I just put this little section here because I thought it was interesting. It said, the prior of Ulsterclough agrees, for he has inquired from the religious men, and especially from the nuns of Gracedew, who dwell near Alan's father's manor of Ashenbury, Brother William, so on and so forth, agrees, for he sued, Brother William meaning a monk, Brother William, for he sued the pleas of the house for nearly 22 years. Huh? Sued the pleas of what? Of Alan's father's house. You see, back then they used to understand that the house was something important, that we were all first a member of our own houses. And then from that standpoint, do we get into larger political aspects or organizations as we see fit through our own volition. But it was always the house first. And so anyway, and that the said Alan was born at the feast of St. Denis proceeding, so on and so forth. So they're just proving that he'd come of full age, right? So that's a proof of age inquisition. And then we do a proof of life inquisition with the VSOF status docs. But this is just a really interesting thing to go read. And it just shows part of the history of it. So, but anyway, not to digress, to get back to the doc. So back to death. But when a person has been absent for a long time, unheard from, the law will presume him to be dead. It has been adjudged that after 27 years, 20 years in another case, 16 years, 14 years, 12 years, 7 years, and even 5 years. See how they just kept working it down and down and down and down? The presumption of death arises, it seems, that even 7 years has been agreed as the time when death may in general be presumed. Now, of course, presumed. What are they doing? They're doing all of this by presumption. Why? Because you haven't rebutted the presumption. Because you haven't rebutted the presumption stands. So from a standpoint that all presumptions stand until they're rebutted is clearly important when it comes to the presumption of death. Because that's what they're doing. They're making sure that everybody's considered dead to the law. So after 7 years of you being abandoned at the hospital by your mother, your estate gets probated and starts to be administered. Remember, they are only administering justice, right? That's what they call it. What are we doing? All the courts will say, we're here administering justice. Administering? Okay. They can then run and administer the use of the property, your body, property of the state, as they see fit under the Roman civil law concept of use and usufruct. So what they're doing is they're fining and feeing you for the use of your own property, like smoking weed, deciding to put something in your body, or mushrooms or anything else they don't like you to, put into your body that might wake you up spiritually, that you're being fined for the improper use of property that you have not yet claimed. That is the gist of everything that's going on in the Roman civil law system. And the idea of use and usufruct is that you have the right to use the thing, you have the right to use your body, but you don't own it. So then they consider you to be a usufructuary, or also what's known as a trustee. Now I'm going to go over two real quick things. I want to show you guys the difference between administrator and executor, so you have a clear distinction as to what these things are, the difference between these. Administrator, trust. An administrator is a person lawfully appointed with his assent to be an officer having jurisdiction to manage and settle the estate of a deceased person who has left what? No executor. Or one who is, for the time, incompetent, right? Infant, that's your infancy right there. You're incompetent. Or unable to act, or simply the fact that you don't act. Nobody acts. Nobody comes and forwards and claims the estate. Okay, so what happens? It gets administered your whole entire life, right? 2, it will be properly considered, first, his rights, secondly, his duties, thirdly, the number of administrators and their joint and several powers, fourthly, several kinds of administrators. Now, you can get into that as far as courts that do set up administrators for various different things. Why do you think you have an administrative section or administrative agency of every single governmental agency? What do you got to go talk to whenever you go talk to an agency? You got to go talk to what? The administration. Why? Because that's what they're doing. It's right in your face. So, administrators are authorized to bring and defend actions. I wonder why every single time you go into court, you're always being, what? Represented by whom? A member of the Bar Association, the British Accreditation Registry. Your estate is being represented by them because you're an infant and you don't know what you're doing. They sue and are sued in their own names as AB administrator of CD, so on and so forth, whatever. there's been talk back and forth a bit in the VSOF about maybe we could do this in suing judges in their administrative capacity and say, okay, hey, administrator, so and so forth, right? Instead of saying judge, so and so forth, just call them administrator and then sue them in their capacity for unlawfully administering your estate. But there's other ways that we can take care of that, which are binding arbitration as well. So, but that's another class. So administrators are general, or those who have right to administer the whole what? The whole estate of the intestate. Now, what is an intestate? An intestate is someone who has failed to create a will. If your estate is intestate, it means it does not have a will. Say, okay, or special, that is those who administer in part or for a limited time. Now, they don't administer for a limited time unless and until we remove them from the rest of the time that they would administer, which would literally be the rest of your life. Okay, so there's different kinds of, there's general administrators and special administrators, all that fun stuff, and so on and so forth. And then you have administratrix, which is just the aspect of a woman, just like you have testatrix for testator and executrix for executor of the opposite. So there's your administrator. So again, point is appointed by what? A court. To do what? To settle the estate of an incompetent. Okay, let's compare that with executor. So executor, trusts. The word executor taken in its largest sense has several acceptations. Might be a misprint. One, executor dativus, who is one called an administrator to an estate. Executor testamentarius, now that's what we do, or one appointed by the office by last will of testator, and this is what usually is meant by the term, right? So we appoint ourselves as executor of our own estates. Now, why can we do this? Because your estate was already probated, but it was probated what? It was probated intestate, didn't have a will. Why would you have written a will before you became 7 years old? You didn't. That's the point. So, in the civil law, the person who is appointed to perform the duties of an executor as to goods is called ares testamentarius, right? Ares. That's another word for heir. The term executor, as said, is a barbarism unknown to that law. What is that law? Civil law. Roman civil law is foreign to us. Always will be. Shouldn't have anything to do with us. Never has had. Right? So, in the civil law, the person who is appointed to perform the duties of an executor as to goods is called ares testamentarius, the term, which is Latin. Of course, Roman civil law, Latin, right? The term executor is said, is a barbarism unknown to that law. When you walk into a Roman civil law court or law merchant court, and you say, Your Honor, I come before this court as the sole lawful executor of the res defendant estate herein. Is there any objection to what I just stated? There will be nothing that they can do. What is he going to do? Say, I'm the administrator. You're fired. What is the district attorney going to do? Stand up, I'm the administrator. You're fired. The sole lawful heir and executor, lawful executor, has been found to be living. That's it. That gets rid of that presumption. Now, it's much better to make sure that all of this is done by paperwork and on the public record long before you ever get into that scenario. Because then you can simply file the documents onto the court record and say, look, get out of my face, because you don't have any power here. All right, number 3, to continue. An executor, as the term is at present accepted, is the person to whom the execution of the last will and testament of personal estate is, by the testator's appointment, confined, and who has accepted the same. So what do? We set up our will, we appoint ourselves as our own executor, and then we do what? We accept it, right? We accept it on the public record. So there's nothing they can do about it. So, and I'm not, now the aspect of executor and the definitions here of continue for quite a long time. So again, I'm not going to read all this again. This gets into the things of what you should do, though, as an executor. He should make an inventory of the goods of the intestate, in which should be filed in the office, meaning the office of executor should prove the will in the proper office, meaning you do so on the probate record, which is the county record, which is why we file all these things in the proper place. He should advertise for debts and credits, right? So that's another thing that we eventually do, is we put put an ad in the paper to say, hey, the such and such estate is being finally settled and redemption is taking place of the said estate. Is there anybody out there that has any debts or credits for said estate? Right? Please come forward. And basically we do that within the doc set. There really isn't any reason whatsoever to put it onto a public notice into a newspaper, but some people have and do want to do that, and that's called a broadside. And that's perfectly fine. You can do that if you want. All you would do would just be to put all of the public record numbers from your status doc set and then put them into whatever state journal or whatever newspaper by statute that the corporate state says, yes, this is the newspaper that's supposed to be used for public notices. And you would then say, to whom it may concern, please take notice that the such and such said estate, that the heir and executor of said estate has been found to be living, and that the estate has been claimed and is to be settled within 90 days, save any debts or credits outstanding, or something to that extent. I was literally just coming up with that off the top of my head, but it would be something to that point. And then you'd put in the status doc public record numbers and say, all concerned now take notice of these public records. So then it's their duty to go look it up. If they see the name of the estate and they go, oh, I don't have any business with that estate, they can just keep on reading the notice section. They don't have to worry about it, right? It still stands as public notice. I think you have to publish for 3 weeks to do a proper broadside. But anyway, to continue here, to keep the money of the estate safely, but not mixed with his own. What do the administrators do all the time? They mix everybody's monies with everybody else's so that no one knows what the hell's going on, right? Big problem with that. Be at all times ready to account and actually file an account within a year. Now, that literally means an action of account, to take account of everything that's in the estate. What do we demand from them in the KW? We demand that they give us a full accounting, because this is what you're supposed to do, isn't it, as an executor, right? So, okay. So anyway, I won't read the rest of this. As I said, it's fairly lengthy as to all the other things that an executor can do, but that was the point that I wanted to make between executor and administrator, okay? Make sure that you understand these two. Always want to be over here, and they are always an administrator until we basically make them trustees. So that's the long and the short of administrator and executor. What I mean about being, to type it out, sure. Okay, I'll repeat it slowly. They'll ask you a question, they'll say, and it's always the first question they ask. They'll say, please state your name for the record. Why? Because they have to set the record as to who the hell's in front of the court. Okay, so set the record straight. And you'd say, I, first middle, your first middle name. If you don't have a middle name, that's fine. Just say I, first name, house of, and then whatever is your last name. Say I, John Henry, house of Doe, come before this court, meaning I exist before this court exists. I come before this court as having been found to be living and as the sole lawful executor and heir of the res defendant estate. Is there any objection to what I just stated? And if there's no objection, you can continue with putting them under the bus by saying, Your Honor, there being no objection, I now dismiss and discharge all charges against the John Henry Doe estate. And technically, you've just ended the court case. Whatever it is, I don't care what it is, because they run everything through Roman civil law and through probate, all of it. Now, to make a point upon that, which is a good segue, I have a fun little document that somebody found from Georgia. It's called the Revised Handbook for Probate Judges of Georgia. It's 2016. I don't know if they have a newer one, but I don't care. So this is the cover page, and I just snagged the cover page of it. And then I snagged the section of probate courts, which I wanted to show everybody. So down here it says, interesting thing, additional jurisdiction and duties of certain courts. Criminal. In counties in which there is not a state court, notice that lowercase s state, that means a court of record. None of the counties are running courts of record. They're all running district courts, which are capital S state courts. The probate court is the traffic court for the county. What? And the judge of the probate court hears traffic, game, and fish and certain misdemeanor cases. Okay. There it is in your face. They are running everything through probate. Now, this is Georgia, but I'm sure you can find the same if you dig into your state. Go find your state's handbook for probate judges. Read the whole bloody thing like I did. Or just get the PDF of it and then search it, which is also what I did. So I searched for the word estate, and I searched for the word, I think I searched for administrator and executor. But anyway, this was after somebody had sent this to me and said, look what I found. And then I went and had my field day with the rest of the book. But anyway, magistrate court. In certain counties, through local legislation, the judge of the probate court also serves as the chief magistrate of the magistrate court. Interesting. Elections. In every county in which a board of elections and registration has not been created, the judge of the probate court serves as the election superintendent for the county. Why is that? Because it's only infants voting. He's only administering infants that are sitting there playing in a sandbox saying, I want to pick this daddy or I want to pick that daddy, right? You should revoke, everyone should revoke their voting license or whatever the hell you call it in your county. Go revoke it, or else it's prima facie evidence that you're an infant, that you have no idea what you're doing. If you were an elector, that would be different, right? Different position. Vital records. In some counties, the judges of the probate court serves as the vital records custodian of the county, maintaining the birth and death records for the county. So there you have it in your face right there. They're running traffic court through probate. They're running all this stuff through probate. Why? Because they're administering estates of infants who don't know what they're doing. Okay, so back to this. So what the Roman scum have done is taken what's yours by right and let you use that property with their permission. Let's get back to Usufruct. Roman civil law. The right of enjoying a thing, the property of which is vested in another. You don't own your own body. You just get to use it for a little while. And to draw from the same all the profit, what? Utility and advantage which it may produce. Why are you filing, again, Class 5 gift and estate tax forms with the IRS? It's because you're a human resource. The estate has a product. It's a resource. It's a human resource, and it has to be accounted for. Why do you think the IRS exists? It's one huge glorified accounting firm for the administration of everything that's going on with everybody's estates. Why? Because they have to keep track of it. Why? Again, because of what I just read, the definition of executor and the definition of administrator. Not to mention it specifically goes all the way back to the Magna Carta, of which I'll get to in a little while. So, provided it be without altering the substance of the thing. They can't alter the substance of the thing. Why do you think we have in this republic, if you still want to consider it that, why do you think we have in this nation, let's put it that way, one of the highest, I think it might actually be the highest, per capita prison populations in the entire world? Meaning there's more men and women behind bars in this nation per capita than in any other nation in the world. But we have some of the nicest prisons. It's because they cannot alter the substance of the thing. They have to keep care of you, the body, the thing, the property, just in case someday that the heir might show up and claim it, right? But when you're potted, when you're a little plant and they pot you in your little spot, they can draw from special drawing rights, IMF, right? World Bank bullshit. This gets deep into the banking system. They get $1,600 and some odd dollars per week for every single infant that they have in their jails. Okay? There's the prison system in a nutshell for you, folks. And that's why Bill Clinton signed the omnibus crime bill with the 3 strikes you're out shit, whatever. So they were just figuring out more ways to, what? To draw off your estate. That's all they're doing. They're nothing but parasites. If every single American claimed their estate tomorrow, the United States Federal Corporation would die tomorrow. It'd die and go bye-bye, and so would the entire Bar Association. But anyway, to continue. Usufruct. The obligation of not altering the substance of a thing, however, takes place only in the case of a complete usufruct. Now, I won't get into what's a complete or incomplete usufruct, but the definition's there. It has to do with aspects of trusts and what is and what is not perfect, and if you're fully able to use the thing. So anyway, usufructuary, one who has the right and enjoyment of a usufruct. That's what you are. When you're still an infant, you're just a usufructuary. You just have the right to use the thing, but you don't own it. Right? So, this is usually, clearness points out the duties of a usufructuary, which are 1, to make an inventory of things subject to the usufruct, in the presence of those having an interest in them. Again, this is an aspect of taking inventory. You have to take inventory and give it to who? Your administrator. Right? This is why you get a receipt for everything at a store. It's not a bill of sale. It's an inventory receipt. It doesn't say bill of sale on it. No, it says receipt. Why? Because this whole entire nation is one big warehouse. That's all it is. Because no one's claimed anything, right? 2, to give security for their restitution when the usufruct shall be at an end. This is why they make you put up a bond in all cases against your estate that they're administering. Why do you have to sign your own bond? The bond's in your name, right? Because you have to give security. 3, to take good care of things subject to the usufruct. This is why they create statutes, acts, ordinances, and codes that regulate how you can use your own body. 4, to pay all taxes and claims which arise while the thing is in his possession as a ground rent. Ground rent. You want to know why you pay property tax? Because you don't own the land. So yeah, what's ground rent? Ground rent is to pay property taxes because you don't own the damn thing, right? So, and there's a whole process. There's a whole vocational science of freedom process for people who want to claim their allodial lands and get it done right, meaning absolutely get it correctly done and claim the forever clause, the addendum clause, in the land patent, which is the paramount title, and then never register it again. Which is how all this happens: is registry under Roman civil law to register all this stuff. Okay, so that's how all this takes into account. Number 5, to keep the thing in repair at his own expense, which is the aspect of you having to get insurance on everything. That's why they can force you into getting insurance on everything. You don't own your car, so they can force you to have insurance on it. You don't own your body, so they force you to have medical insurance on it. And the fact that every single insurance contract is under maritime amity law. It's adjudicated under maritime amity law. Just important side note. So if this is confusing to you, you may want to read this article for a better explanation of the origin of uses and what the Romans did. And that's a Wikipedia link, which you can find in the doc. And that'll tell you a lot more about usufruct and usufructuary if you want to get into it. So you just learned the true reason why they make you pay property taxes. It is for the use of property which belongs to another. Get it? All the allodial land titles have been abandoned and have not been reclaimed. Only you can settle your estate because only you can make and file your own will. File a proof of life and proof of age inquest, appoint yourself executor, and you are the only sole lawful heir. No one else in the world can do this for you. I am sick and tired of having people come to me and say, well, Anna Von Dipshit did this for me, and she did that for me, and she did that. And I said, you don't even understand what she's doing. She's stealing everything from you because we are waking too many people up with what we're doing. Every single thing that Anna supposedly does for people, she stole from us, because I've been at this a lot longer than she has. Except we're actually teaching people how to claim the estate. And it's funny, in one of her stupid little writings I just noticed the other day that somebody sent to me, she said, yeah, back in, I don't know what year it was, she said, a lot of them, the corporations and whatnot in the corporate state, stopped using the estate name. But she doesn't explain why, because she doesn't know why. Because it was what we were doing. Because once we put this doc set out there, they didn't want to have every single agency of the federal government automatically under the bus. So they altered the way they were doing business. Not all that different from when we shut down the IMF. Or I should say removed the United States Federal Corporation from the IMF back in 2014. Anna is an agent. Period. Full stop. She'll never explain anything of what she's doing because nothing she's ever going to do for you works. Furthermore, I looked at her doc set the other day, or what somebody had sent to me about part of her doc set. She has everybody sign at the bottom without prejudice. You know what that means? It means you don't mean anything by signing this, right? So nothing that she ever does will ever work for anybody. And then she has the audacity to yell and scream at my friends in Michigan, Destry and the rest of the gentlemen who I know over there who also do good work, that no one should pay attention to what they're doing because they're not following my system. Well, whatever. You're an agent. So anyway, I'll get off my soapbox regarding her. No one needs to pay any attention to anything she does, period. Anybody that comes up to you and says that you should look at her garbage, forget about it. Just bring them here. Citizen versus people. Which one are you? Now, this was taken from 1215.org, which is, of course, Bill Thornton's website. And it's not my work. So this does not come from me. This comes from his site. I won't read this whole thing, but it's an aspect of the difference between what a people is, meaning from an aspect of the preamble, that we the people of the United States, in order to form a more perfect union, establish justice, so on and so forth, yada, 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 do ordain and establish this Constitution for the United States of America. Okay, what does ordain mean? It means to create law. What does establish mean? It means to put it down on a piece of paper. That's it. So we, the sovereign people, ordain and establish this Constitution for who? Everybody who wants to swear an oath and allegiance to it. the United States of America, for the United States of America. This is a trust which was established, not with this document, by the way. This trust was established by the Articles of Confederation. Then this document came along later and then gave it a constitution for this thing, which was basically 19 enumerated, 19? I think so. 19 enumerated services that the states didn't want to take care of. So the states themselves entered into a trust. They gave this thing a constitution, and that's what that thing is. It has nothing to do with you. Never has had anything to do with you. Period. You're above it. In fact, everybody thinks, oh, the federal government's above the states. No, it's not. The federal government is below the states if the states were acting properly as republics. And the states are below us if we would be acting properly as grand juries. Okay? So, but anyway, I won't read the rest of this, but it's just basic between are you a people or are you a citizen, right? So always be a people. It's got plenty of documentation and all the proof you need. So now back to it from my side. Nationality at birth and collective naturalization. 8 USC, that's United States Code, 1401. Nationals and citizens of the United States at birth. Now, people have been coming to me for years and saying, well, I'm a national. Really? You really want to be a national? I don't think so, because you didn't go do your research. The following shall be nationals and citizens of the United States at birth. So I don't care. It's the same thing. Citizen of the United States, by the way, under the 14th Amendment, is one who is born or naturalized in the United States and subject to the jurisdiction thereof. And subject to the jurisdiction thereof. If you're not subject to the jurisdiction thereof, can you be a citizen of the United States? The answer is no, you cannot. Just to make a point of that, I'll bring this up really quick. You know what? It's on the server. All the more reason to join the server. So anyway, it's under Law Media all over the bottom. Read Elk versus Wilkins. Elk versus Wilkins will tell you in this one. I'll read it even though it's probably impossible for somebody to see. It says that the court decided that even though Elk was, and he was a Native American, even though Elk was born in the United States, he was not a citizen because he owed allegiance to his tribe when he was born rather than to the U.S. and therefore was not subject to the jurisdiction of the United States when he was born. Okay? Just a little side note there. Just want people to understand that this is not something I'm making up. I will back every single thing I say up. Again, take another shot at Anna Von Idiot. So, back to this. The following shall be nationals and citizens of the United States at birth. : a person of unknown parentage, foundling, in the United States while under the age of 5 years. 5 years. They only give you 5 years. Until shown, prior to his attaining the age of 21 years, not to have been born in the United States. Were you born in a territory of the United States? No. You were born in one of the republics. You know, you were a Wisconsinite, or you were born Michiganian. You were born as one of those people. Now, because of the contracts and little things that they shoved in front of your mother's face that she didn't know anything about, they bring in the presumption that you're not that you're something else. And then they try to, and this of course is ridiculous because here's the thing about this. What I'm reading is United States Code. United States Code is Roman civil law. There's a maxim of law that states that the rights of blood and kinship cannot be destroyed by any civil law. Okay? So this little thing that they're trying to do here, prior to his attaining the age of 21 years, meaning after you, because somebody brought this up to me, they're like, well, once you turn 21, it says you can't go back. And I said, bullshit. I call shenanigans on that completely because of that maxim that I just stated. I don't care what they want to try to lock you into. The maxims of law supersede any Roman civil law, period. Because maxims of law are common law. And they totally supersede any written Roman civil law or municipal law that they want to write. Always. So I don't care what this says. It's irrelevant because your right to blood and kinship outweigh this. Also, another reason that they outweigh it is because specifically in the Magna Carta, it states that matters of life and limb. Now I'm going to possibly paraphrase. I might butcher this a little bit, but I believe it says matters of life and limb shall be considered gratis and cannot be denied. So what does that mean? So if your life depends on your estate, that's a matter of life and limb. And the claiming of your estate and to having to hold your estate, that's a matter of life and limb. It cannot be denied. It must be considered gratis and it cannot be denied. That's why nobody can argue the status tax, because we say right in them, this is a matter of life and limb. Sorry, there's nothing you can do about that. There's nothing they can do about it, I mean. So anyway, to continue. So, what's the point here? A person of unknown parentage found in the United States while under the age of 5 years until shown prior to his age of attaining 21 years not to have been born in the United States. There's your presumption. So just rebut it. Rebut your presumption. That's what we do with the Declaration of Nationality. Status doc. We correct all this garbage in that doc when it comes to the nationality and where you're from and so on and so forth. And then we crush all the rest of it and all the rest of the documents. So if people want to get on some kind of bandwagon about being a national, well, they're still found to be a citizen of the United States at birth. So that ends that argument. The hospitals are called Foundling hospitals, run by the Knights Hospitallers to this day. What is a foundling? VSOF dictionary, again, a foundling. A newborn child abandoned by its parents who are unknown. The settlement of such a child is in the place where found. That's why you have to do it in an action. Because maybe you were abandoned in Tennessee, but you fix the probate record and you file your court of record and you're all of a sudden found in Wisconsin. Okay, then guess what? You settled your estate in Wisconsin. Doesn't matter. Makes absolutely no difference whatsoever. But make note, a foundling. A newborn child abandoned by its parents who are unknown. The settlement of such a child is in the place where found. So, does it matter where your birth county is? Nope. Do you have to file your doc set in your birth county? Nope. So, you want to think of the word settlement in this way, not as settlement of an account. Well, you kind of can do it also, but of you as a man settling in a place where you have your lawful domicile. It's both. I actually should probably fix this because, truth be told, it is both. But you should think about it from the same point of, this is where I'm settled. This is my lawful domicile. This is my homestead, if you will, right? Because you can only have one domicile. You can have as many residences as you want. You can have a residence in every country in the world, but you can only have one lawful domicile, one. And that's where you're considered to be one of the people. That's where your power over your native land is, if you want to put it that way. So now, if you are found on a piece of filthy spell bond paper where your little feet were put when you're at the Foundling Hospital, then the first place your feet hit was not on the ground, it's not on the soil of the earth, but into bondage with the corporate state of Illinois or whatever it was, controls your entire life. You ever wonder why the first thing that they always do when a new baby is born, after they wash them and take them back, the first thing they do is get out that ink pad? You ever notice that? Well, those of you who have children, or those of you that have gone through the process of such, or know someone that's done that, they'll tell you. That's the reason. They don't want to lose and get away from the presumption that you're a foundling, that you're abandoned. And this is because, again, the signing of the birth certificate form and submitting it to the corporate state, the mother becomes an informant. An informant. Someone who informs on their child. So they abandon their own child and then they inform on them by document at the Foundling Hospital. The state then keeps the child as a ward of the state and tells the mother and father that what can be done with that child for the rest of its life. They can do this because you registered the child with the birth certificate contract, and eventually the state then deposits the birth certificate into a trust company, and like I said, most likely a DTCC. So a depositor contract, he who makes a deposit is generally entitled to receive the deposit from the depository, but to this rule there are exceptions, as when the depositor at the time of making the deposit had no title to the property deposited, like attorneys, and the owner claims it from the depository. That's what we are. The depositor cannot recover it. Once you claim it, it is yours. The Bar Association can never come back over the top of you, period. That's why you have to be the owner. The three most powerful words for this whole thing, well, there's more than three, but heir, executor, or executrix, as the case may be, and donor, and owner. So basically four. Executrix, or executor, as the case may be, heir, owner, and donor. Those are the four most powerful positions to be in this whole entire filthy Roman civil law system. Okay, so just remember that. So once you come of full age, only you can be the owner of your own estate, not your mother and not the corporate state. Once you come of full age, it's your responsibility to claim and have and hold your own estate, and that means above anybody else. You don't have a higher landlord, right? So this is why your suing out your livery of your estate can only happen at the probate court of the birth county. Now, what we've realized is that again, I need to update this because this is slightly off. We don't need to sue out the livery at the birth county. What we do is we sue out the livery at where? At the place where the child is found. So you sue out your livery by doing your doc set wherever you happen to be, and then what we do is we turn around and we file it with the birth county. We turn around and we give them notice that we've done this at another place. That's how we do this now. So again, some of this document needs to be updated, but so that's what we're doing. All right. However, it may have to be done with the Superior Court of the District of Columbia. That's still something we're looking at. It's a possibility that we might have to put the District of Columbia underneath the bus directly, or simply by taking the doc set and giving the District of Columbia probate registrar, which there is such a thing, notice of the entire doc set. No one has done that yet, by the way. So I'd be very, very interested to see what happens when that does happen. I just got to find the address. And then after we get the full doc set done, then we can just send them a notice. We can do the ordinance of the estate, file that, and then basically just file the ordinance of the estate with the District of Columbia registrar, and putting them on notice of the rest of the public records filed onto the county recorder's office, wherever you guys have filed your doc set. So yeah, because we claim it at the county record, and then you notice everybody else after you've done this. So because it is where your estate was probated, because you never came forward to claim it in 7 years, and then after 21, they figured no one will come forward and claim it, and the body and property of the state become basically a permanent pledge to the United States Federal Corporation for the debts of congressional bankruptcy, which has happened several times and is still going on, meaning the bankruptcy is not the pledging. The pledging only happens once. Okay, so however, based on the above definition, when a claim is made upon the deposited property, the BC and the estate, by one who has no title to the property, then the depositor cannot recover it. So they don't have any title to it. You come forward, claim the title, and as it says here, the depositor cannot recover it. And for this reason, he cannot ever be in a better situation than the owner, right? That's important. This whole aspect that he can never be in a better position than the owner is really, really important. And you know what? There's something else that I should point out too that I didn't put into this docs, or didn't put into the class docs, but I'll bring up. It's something I found in Illinois law a long time ago, and it's really interesting regarding the aspect of a sheet. This is a really interesting thing from Illinois statutes. When I saw this, I was like, you gotta be kidding me. It was right in your face all the time. So Illinois Statutes, Conveyances Act, property, conveyances. Livery of season shall in no case be necessary for the conveyance of real property. I wonder why, because that's a common law thing. But every deed, mortgage, or other conveyance in writing, not procured by duress, which is why we say everything that we've entered into with the corporate state is under duress. That's part of the reason we get rid of that shit. And signed by the party making the same, the maker or makers, being of what? Full age and sound mind. It's right in Illinois statutes. The common law aspect of what we're doing is right in the statutes, at least in Illinois. I'm sure you can find it in every other state too. But anyway, shall be sufficient without livery of season for the giving, granting, selling, mortgaging, leasing, or otherwise conveying or transferring any lands, tenements, or hereditaments. A hereditament is something that's on the soil in this lowercase s state, so as to all intents and purposes absolutely and fully to vest in every donee, grantee, bargainee, mortgagee, leasee, or purchaser all such estate or estates as shall be specified in any such deed, mortgage, lease, or other conveyance. Period. Now here's the fun part. Nothing herein contained shall be so construed as to divest or defeat the older or better estate or right of any person or persons not party to any such deed, mortgage, lease, or other conveyance. What does that mean? It means I don't give a flying fuck how many times they've hypothecated, transferred, leased, bonded, anything of my estate. I don't give a damn. Nothing herein contained shall be so construed as to divest or defeat the older or better estate or right of any person or persons not party to such deed, mortgage, lease, or other conveyance. When I come forward as the heir, I don't give a damn who's holding on to my property. It's mine. And you had better give it back, because under pain of death, I will take it from you, because that would be common law theft, now wouldn't it? That's right, because first time offense under common law for thievery is death. So once I put you on notice and all the world on notice that, hey, that's mine, you've got I give you 120 days to give it back to me and give me a full accounting. right? Which is what you're supposed to do anyways as an administrator, as we already saw today. But you don't do that, you're mine. All the way mine, which I showed in the last couple classes when we went over the binding arbitration that we've already got against sitting judges for millions of dollars. So, Section 2, every estate, gift, grant, deed, mortgage, lease, or confirmation of lands, tenements, rents, services, or hereditaments made or had, or hereafter to be made or had by any person or persons, again, being of full age and sound mind, and not procured by duress, so on and so forth, and blah, 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 blah. I won't go into all the rest of that. And against his or what? Their heirs, claiming the same only as heir or heirs, and each of them, and against all others having a claim or title or interest in the same, only to the use, not ownership, use of the same judgment, debtor, seller, grantor, so on and so forth, right? Of his or her, their what? Heirs. Again, you have to be the heir at the time of the judgment, enforcement, bargain, sale, so forth, so forth. So I'm making a point here. If you know what you're looking at, you can go read these statutes and everything's in your face if you know what you're looking at, right? So anyway, didn't want to digress there, but I thought it was real, and I'll put the Illinois statutes in the, well, I'll make sure I upload them into the mega folder. Another little side note thing of here that I had. So chancery, equity, and requirement is a requirement of a trust, okay? So whenever you're in a chancery or equity court, which is what all these courts are, they're all chancery and equity. Little note on chancery. Chancery is a jurisdiction of English jurisprudence that came into existence in, I believe it was Henry III's reign, I think. Don't hold me to that, though. I make sure that I cover it in another class. That what he did is that the attorneys all went to him, the Knights Templars, who are the Bar Association, run out of the City of London and the Inner Temple and Middle Temple courts. And that's why you know your ins and outs of court. And they went to the king and they said, hey, king, you look really busy over there in your court of record and King's Bench. You want to maybe have some of this business adjudicated over here? Because, common law doesn't really recognize trusts very much because it's a filthy Roman civil law shit pile of garbage. They said, well, let's set up a different jurisdiction over here. We'll call it chancery. And I'll tell you what, we'll hold your conscience. What? They literally said that they'll hold the conscience of the king and do what is equitable and fair and just in matters of trust. So the point is, go look it up. An Elementary Treatise of the Common Law for the Use of Students by Henry T. Terry, 1906, page 23, section 38, quote, says, first, equity recognizes and protects certain rights of which the law takes no notice. The law means common law. These are called equitable rights or trusts. Everything that is in trust, that deals with trust, is being run through chancery and equity. All the rest of the other garbage is being run through maritime amnesty and the law merchant. That's your contracts and that you contract yourself into. Okay, but first, everything starts with the aspect of the estate. And my point with this is that you cannot have a trust without first having an estate. The estate comes first. Absolutely 100% first. And to slap Anna Von Idiot in the face one more time, it's another thing she doesn't understand, or specifically lies about. It's the trusts that get created from the estate. The estate has all of the res. If you claim the estate, all of the rest of the trusts go away. All of them. Why? Because they can't have in trust what is by law, again, which law takes no notice, which by law belong to someone else. If we claim our estates, we claim everything away from the filthy cult of Rome, which she worships. She pledged her whole entire existence to the cult of Rome. She even gave oaths to the filthy Pope. Okay, I want Rome destroyed tomorrow. All of it. So understand that this aspect of trusts and use and usufruct, this is all Roman filth, all of it. So make a note of that. If you want to, you can download this book on archive.org. Just, I think you pretty much just copy and paste this and go grab it off of archive.org. It's a really good book to read anyway, but this particular part was pertinent to tonight's little discussion about trusts and usufructs and all this good stuff. Okay, another thing to cover just really quickly. I probably won't get through the rest of the doc tonight, so I guess maybe we will leave this for next Saturday. So we'll get into what is a person and cover this next time. But just one last little thing, another little interesting point of reading, to focus on what the remedy used to be when I was talking about the proof of life and proof of age inquest, or particularly the proof of age inquest that I showed you in the main chat earlier today. Okay, so where was the remedy of that in English jurisprudence? It was in the Court of Wards and Liveries. There was a specific court, which they had, called the Court of Wards and Liveries. Now this, whoever this gentleman was, wrote this thesis paper. This was for requirements of a Master of Arts degree. It's a very interesting, fun paper. It was written in 1905, and it tells you everything about the Court of Wards and Liveries. That the war that was going on between Parliament and the King at the time, and that they, this is what they were doing, and everything's, all of the fun stuff about the estates and the Magna Carta, it's all in here. Because it has to be short, because it's a master thesis, so it can't be too bloody long. It's 114 pages. Okay, it's a little bit long, but it's a searchable PDF. So meaning, I made sure that it was searchable. So you can click in here, and all you have to do is just hit Control F, and the little find thing comes down, and then you can type in words like estate and heir and foundling and all kinds of fun stuff, and have fun with it, because it showed me a lot that I didn't know before. It was fairly fortuitous that I ran into it. So you guys can take a look at, like I said, at your own leisure. And with that, I think I will call it a night, and I'll make a note here. I'll just make this red for a second so we know to come back here. Okay, so with that, we'll come back to this next week. So with that, if anybody has any questions, feel free to ask them, but right now I'll turn off the recording and we can talk amongst ourselves.